I have been talking about data protection in the EU a lot, haven't I? Well, then let's talk about data protection in the United States. I actually did see a article about US lawmakers possibly coming together to create a comprehensive federal data privacy bill. So, what data protection laws exist in the United States? Well, on the federal level, there is the Data Privacy Act of 1974 that governs how federal agencies can collect and use data about individuals in its system. The act prohibits agencies from disclosing personal information without written consent from that individual, subject to limitations including the Census Bureau for statistical purposes. Individuals reserve the right to request their records, request a change to their records if they are incomplete or inaccurate, and to protect against unwarranted invasion of their privacy. Then there is HIPAA, which you have probably heard a lot about since the COVID vaccine. HIPAA stands for Health Insurance Portability and Accountability Act. It was signed into law in 1996 by President Clinton, creating standards for how health care providers can use a patient's personal health data. HIPAA only applies to covered entities such as providers, a health plan, and healthcare clearinghouses, which process medical information. Under HIPAA guidelines, covered entities must comply with an individual's right to see their health information, correct their health information, and covered entities cannot use or share health information without the individual's written consent. Keep in mind that health information not shared by a covered entity is not subject to HIPAA regulation, meaning that health data that you share with a nutrition app or on social media is not covered. Other institutions that are not considered covered entities that handle health information, like schools and employers, are not subject to HIPAA regulation but may be regulated by other laws. There is also the Gramm-Leach-Bliley Act, which was signed into law by President Bill Clinton in 1998. The GLBA covers data privacy for financial institutions. The law requires that these institutions have a policy in place to protect customer data from security threats, and institutions must provide customers with a privacy policy explaining what information is collected about the customer and where it is shared, and to inform the customer of their right to opt out of the information being shared with unaffiliated parties. There is also the Children's Online Privacy Protection Act that was signed into law in 1998, which places limits on what companies can do with data collected about children under 13 years of age. Companies and websites that may collect data from children under 13 must post an online privacy policy that details their data practices and must obtain parental or guardian consent before collecting personal information from children. Parents must have the opportunity to access their child's data, review, or delete it and prevent the company from collecting further data about their child. Companies must also maintain the confidentiality of data collected from children and must only keep it as long as necessary to fulfill the purpose for which it was collected. On the state level, there is the California Consumer Privacy Act that was passed in 2018 and is known as the strictest data privacy law in the USA. The CCPA applies to business that collects personal information about consumers and outlines specific rights consumers have. This act applies to companies that process personal information of Californian residents and either have $24 million in annual revenue, hold personal data of 50,000 consumers, or have at least half of their revenue from sales of personal data. The CCPA was updated with a second act, the California Privacy Rights Act, which was passed in 2020 and took effect last year. This extended the rights of consumers to include the right to correct inaccurate data a business collected about them and the right to limit the use and disclosure of sensitive data. Furthermore, Virginia became the second state to pass a comprehensive data privacy legislation with the enactment of Virginia Consumer Data Protection Act. The law went into effect January 1st of 2023. This was followed by Colorado that signed the Colorado Privacy Act into law on June 8, 2021, and it became effective as of July 1st, 2023. And Utah on March 24th, 2022, with its Consumer Privacy Act, which takes a business-friendly approach to privacy protection. It went into effect on December 31st, 2023. Delaware, Florida, Indiana, Iowa, Montana, New Hampshire, New Jersey, Oregon, Tennessee, and Texas have all passed data privacy bills that will take effect either this year, next year, or in 2026. If you would like me to create an infographic of each state, let me know in the comments and I will keep you updated on the process of the discussions on the new federal data privacy bill. Which country should I do next? China, Japan, Kenya, or Brazil? Let me know in the comments.